Hey, there I am. Sorry about that, folks. Welcome to today's Law of Self-Defense show. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you. Thank you very much. We have a lot of streaming going on today. Yep, looks like YouTube is working correctly. Looks like Rumble is working correctly. Let's see. Law of Self-Defense members only page working correctly, and I think I should be streaming to Twitter. Indeed. Holy cow, I'm streaming on Twitter. I can't believe it. All right. Very exciting. 4 streams going out at the same time. It's like just like the prom. All right, folks. Welcome everybody. I really appreciate you being here. As usual, this is going to be a bifurcated show. So the first part of the show is going to be simul-streamed on a whole bunch of different platforms, YouTube, Rumble, Twitter, and of course for our Law of Self-Defense members on their dashboard. And then at some point, we're going to cut over just to our members. The members won't have to do anything. They just stay where they are, but all the other streams will be cut off, except for the Law of Self-Defense members, because we're going to show the video of this shooting. 2 videos, actually. One is the body-worn camera video of the officer involved in the shooting, which actually cuts off before the shooting because the camera becomes deactivated in the fight. But then we also have video taken by a bystander's phone that shows the actual shooting. And for sure, if, well, you know what will happen if I show that on a normal public stream. So we won't do that. We're going to keep those videos as usual for Law of Self-Defense members content. What we'll talk about first are kind of the legal principles, what's happened in the case. We just had a very important court ruling in this case. And of course, this is the Patrick Lyoya shooting out in Michigan, where a white police officer shot a violently non-compliant black suspect. The usual crew is involved now. Benjamin Crump, of course, has become part of this case. And we have some breaking news just from, I believe, just from yesterday. And that is that they had the probable cause hearing for this officer. The officer had been charged with murder by the state of Michigan for this killing. And they had what's called a preliminary hearing, a probable cause hearing, where the defense is demanding the state show probable cause. That this was in fact a crime, and the judge presiding over the hearing makes that determination, and he decided in a lengthy written ruling, several pages, and we're going to go through all of it, that there existed probable cause in this case for this officer to go to trial on a charge of murder. I frankly disagree with that opinion, but I think in part what we're dealing with here is a function of the broken nature of the legal concept of probable cause as a barrier to prosecution, a defensive barrier for people who ought not be brought to trial. And it's important to have those barriers because otherwise we live in a gulag nation. The state is supposed to overcome certain barriers at certain part of the criminal process. The most important to us being, other than, of course, being found guilty by a jury, but the most important barrier prior to that point is really this probable cause hearing, where it's determined whether or not there's enough of a case to take you to trial in the first place. And the reason that's important is because of the very destructive nature of the trial, the temptation for the state to use the process itself as the punishment, the hundreds of thousands of dollars in legal fees, the months or years out of your life. And that's all true even if you're acquitted at the end. Plus, you may not be acquitted. There's a certain amount of noise in the system. There's always a 10% chance of getting convicted, no matter how innocent you are, if you're put in front of a jury. So you don't want to be put in front of a jury and incur that risk unless there's good reason for it. And the reason is not supposed to be political. The reason is supposed to be legal and a function of the application of law to the available evidence, the available facts in the case. And this kind of probable cause judgment is often difficult, especially where facts can be ambiguous, where facts are being contested. And often in those cases, you'll see the inclination of the judge is to, well, if the facts are ambiguous or judgment calls need to be made about the facts, they feel more obliged to advance the case and put it in front of a jury, because it's supposed to be the role of a jury, really, ultimately, to be the finder of fact in a criminal case. One of the main reasons I object to this finding of probable cause here is, one, I don't think it's substantively found in the evidence. But second, there really are no disputed facts here. The entire event was captured on video, so there's no ambiguity. There's not like there's witnesses who are telling different versions of what happened, and you need a jury to decide credibility here. Everything's really on video that you would need to know, and obviously the judge has seen the video. So given the lack of ambiguity about the facts, in other words, the certainty of the facts, I just don't see probable cause here for this prosecution. If we define probable cause as I believe it ought to be defined, so that'll be part of today's show and discussion. Okay, so with that, a quick overview. Let me just pull up a news report here. It's only a couple of paragraphs, and then it dives into the court's actual ruling, which is what we'll cover. Let's see. Share. Where's my Chrome tab? Sorry about the ads here, folks. I have to turn off ad block in order to show this to all of you. And of course, as some of you may know, a fellow lawyer paid for my very nice watch recently, so I'm getting lots. Given the nature of the internet, I'm suddenly getting lots of watch ads. I didn't buy an Omega, by the way. I bought a Rolex. So, headline: read judge's full ruling in ex-Grand Rapids police officer's fatal shooting of Patrick Lyoya. I don't think aware that the officer had in fact been fired, but apparently that's what that headline suggests. The rest of the article still calls him police officer. Oh, former police officer. Fair enough. But here's the article. After 2 days of testimony, Grand Rapids District Judge Nicholas Ayub, that would be the gentleman, I believe the gentleman in the, well, now I'm not sure actually which of those men it is. No, it must be the one in the lower right here with the big chair. That would be the judge's chair. Not that it matters what he looks like, but Judge Nicholas Ayub on Monday, October 31st, yesterday, ordered former Grand Rapids police officer Christopher Schurr to stand trial on second-degree murder charges in Patrick Lyoya's killing. Schurr, the officer, 31, shot and killed Lyoya, 26, on April 4th after a traffic stop. The two fought for control of the officer's taser, which was discharged twice without hitting the suspect before the officer shot him in the back of the head. And in a courtroom packed with supporters of both the suspect and the former officer, the judge read an 11-page opinion below. And we're going to step through all of that opinion. I may skip paragraphs here and there if they get unnecessarily technical, but I don't recall any of those, so we'll probably go right through the case. Now, before we do that, I just want to refresh everyone's recollection on what's happening here. So this is not a hearing where guilt is determined. This is a hearing to determine whether or not this officer, this defendant, this accused, should be advanced to the next step of the criminal justice pipeline, from having been arrested, charged by a prosecutor, now going to trial. So a jury will be selected, and the case will proceed to trial, and some verdict presumably will be arrived at the end of the day. And there's various thresholds of evidence that are required by the law to advance further up the pipeline all the way through conviction, right? For conviction, obviously, we need proof beyond a reasonable doubt to the satisfaction of the jury of each and every element of the criminal charge. And in a case like this, that's going to involve a claim of self-defense, we also need proof beyond a reasonable doubt to the satisfaction of the jury that the state has disproven self-defense beyond a reasonable doubt. So, but that's the highest threshold we have in the law, is proof beyond a reasonable doubt. There's lots of lower thresholds of evidence, and in part, the height of the threshold of evidence required in any particular step in the process is partly a function of the threat to the defendant. All these thresholds are intended to protect the defendant, the accused, from the power of the state, right? That should go without saying, but who knows? It's 2022. I don't know if they teach this kind of stuff in school anymore. So when a prospective state action in this criminal prosecution process is a relatively modest interference with a suspect or an accused or a defendant, the threshold of evidence typically required for the state to engage in that infringement is similarly modest. It's proportional to the level of inconvenience to the client. When we get to the other end of the spectrum, so when it's a small inconvenience, relatively low threshold of evidence required for the state. When we get to the ultimate level of convenience, which of course is stripping an accused of their liberty, convicting them, finding them guilty of a crime, and sentencing to some term of years in a prison, it's a very high threshold of evidence required for that. The highest that we have, proof beyond a reasonable doubt. But in between, there's a lot of intermediate levels of evidence, one of which is probable cause. And where I think probable cause should appropriately be placed is not, in fact, where it is placed in our current legal system. And that's why I think probable cause in America is a broken legal concept that's not adequately serving its intended purpose. So, of course, we do legal analysis and education here at Law Self-Defense. So I actually have a little PowerPoint slide. I think I have a little PowerPoint slide.